You are in a small room inside Phoenix Police Headquarters. It is the 13th of March, 1963. The air is dry, the way it always is in early spring in Arizona, a heat that hasn't yet swelled into summer, but already presses against the skin. The light from the single bulb overhead is pale, institutional. It hums, faintly, the way fluorescent tubes do when they've been left on too long. There is no window. The walls are painted a color that might have once been cream, but now looks closer to the shade of old paper. You can hear footsteps in the hallway outside. They echo, then fade. The room holds a metal table, 2 chairs. A man sits in one of them. His name is Ernesto Miranda. He is 23 years old. He has dark hair, a thin mustache, and his hands rest in his lap. He is not handcuffed. He has been told he is free to leave at any time, but he does not leave. He sits still, his shoulders slightly hunched, his eyes moving between the 2 detectives standing near the door. They do not shout. They do not threaten. Their voices are measured, almost kind. You sit in the corner, invisible, watching the way the light catches the edge of the table. You feel the stillness in the room, not peace, but something heavier, the kind of quiet that comes before a confession. One of the detectives leans forward. His name is Carol Cooley. He has done this many times before. He knows how to read a man's breathing, the twitch of his fingers, the way his gaze drops when a question lands too close to the truth. He speaks slowly, each word deliberate. "We know you were there," he says. "We just need to hear it from you." Miranda shifts in his seat. He looks at the table. His hands open, then close again. You notice the way his breath changes, shorter now, shallow. You notice the way the room seems to contract around him, the walls pressing in without moving. There is no lawyer present. There is no one to tell him he does not have to speak. There is no warning, no ritual recitation of rights. Just 2 men, standing, waiting, and 1 man, sitting, beginning to break. He does not ask for a lawyer. He does not ask to leave. Instead, he speaks. It takes 2 hours, maybe less. The detectives take notes. They nod. They do not interrupt. When he is finished, they ask him to write it down. He does. The handwriting is uneven, the sentences simple. At the top of the page, someone has typed a brief statement. I, Ernesto A. Miranda, do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. He signs it. You watch him sign it. You see the pen press into the paper, the ink darkening the fibers. You see the detectives exchange a glance, not triumphant, but satisfied. This is how it is done. This is how it has always been done. The confession will be everything. It will be read aloud in a courtroom. It will be examined, dissected, defended, and challenged. It will become the axis around which the entire case turns. But right now, in this moment, it is just a piece of paper on a table in a room with no windows. Miranda is let out. The door closes. The hum of the light remains. You sit in the silence that follows. You feel the weight of what has just occurred, not the violence of it, but the softness. The way a man can give himself away without ever being asked to fight back. And you begin to wonder, what happens when no one tells you that you don't have to speak? The story begins, as many legal stories do, not with the law, but with a person. Ernesto Miranda was born in Mesa, Arizona in 1941. His childhood was fractured. His mother died when he was young. His father remarried. School was difficult. He dropped out in the 8th grade. By the time he was a teenager, he had been in trouble: theft, car theft, small crimes that accumulated like stones in a pocket. He spent time in reform school. He spent time drifting. He was not a hardened criminal. He was not a mastermind. He was a young man on the margins, moving through a life that had never quite fit him. In March of 1963, he was working as a laborer. He lived with his common-law wife and her daughter. His days were ordinary, until one night they were not. A young woman, 18 years old, was abducted from a bus stop in Phoenix. She was driven into the desert, assaulted, and then released. She went to the police. She gave a description: a man in his early 20s, driving an old Packard, with a particular scar on his hand. The police began searching. They found a car that matched the description. They found Ernesto Miranda. He was brought in for questioning. The young woman was asked to look at a lineup. She identified him, though not without hesitation. The detectives took him into the interrogation room, and there, in that small, pale room, he confessed. You stand now in the aftermath of that confession. You are in the Maricopa County Courthouse, months later. The trial has begun. The courtroom is wood-paneled, formal, thick with the smell of old varnish and paper. The judge sits elevated, his robe a pool of black against the bench. The jury sits to the left, 12 faces, some attentive, some already weary. The prosecutor stands at a lectern, his voice clear and sharp. The defense attorney, a court-appointed lawyer named Alvin Moore, sits beside Miranda, flipping through notes. You watch as the confession is entered into evidence. The prosecutor reads it aloud. The words hang in the air, flat and final. The jury listens. Some take notes. Some simply stare. The defense objects. Moore rises, his voice calm but firm. He argues that the confession should not be allowed. He argues that Miranda was never told he had the right to remain silent. He was never told he had the right to a lawyer. He was interrogated in isolation, with no one to advise him, no one to protect him from himself. The judge listens. Then he overrules the objection. The confession stands. You feel the shift in the room, subtle but unmistakable. The trial is no longer about what happened in the desert. It is about what happened in that small, pale room. The jury deliberates. It does not take long. They return. The verdict is read. Guilty. Ernesto Miranda is sentenced to 20 to 30 years in prison. You watch him as the sentence is pronounced. His face does not change. He stares forward, his hands resting on the table. He does not speak. He does not cry out. He simply sits, absorbing the weight of the words. And then he is led away. But the story does not end there. Alvin Moore files an appeal. He takes the case to the Arizona Supreme Court. He argues, once again, that the confession should not have been admitted. He argues that Miranda's rights, whatever those rights are, were violated. The Arizona Supreme Court hears the case. They deliberate. They rule. The conviction is upheld. You sit in the quiet after the decision is handed down. You feel the finality of it, the way the legal system closes around a verdict like a fist. The case is over, or it should be, but something stirs. The American Civil Liberties Union takes notice. So does the National Association of Criminal Defense Lawyers. They see in this case something larger than one man's confession. They see a question that has been waiting, unanswered, for decades. What does the Fifth Amendment mean when you are alone in a room with the police? The Fifth Amendment to the United States Constitution is brief. It says, in part, "No person shall be compelled in any criminal case to be a witness against himself." It is a promise, a shield, a line drawn between the state and the self. But for most of American history, that line has been blurry. The amendment protects you in court. It protects you from being forced to testify. But does it protect you before the trial begins? Does it protect you in an interrogation room? No one has ever said. The lawyers decide to ask. They petition the United States Supreme Court. They argue that Miranda's conviction should be overturned. They argue that the Constitution requires something more than silence from the state. It requires speech. It requires warning. It requires that a person be told, clearly and explicitly, that they have the right not to speak. The Supreme Court agrees to hear the case. You are standing now at the threshold of something rare and enormous, a case that will ripple outward, beyond this man, beyond this room, beyond this moment. A case that will rewrite the language of American justice. The date is set, February 28th, 1966. You sit in the stillness before the storm. You feel the weight of what is coming, not yet verdict, not yet law, but the slow gathering of voices, evidence, argument, principle. The courtroom is waiting, and so are you. The confession is given, the trial is held, the verdict is rendered, but the question remains, when does silence begin? You are in Washington, D.C. It is winter, 1966. The city is cold, gray, layered with the kind of damp chill that seeps through wool and settles in the bones. The trees along Constitution Avenue are bare, the sky is low. You walk up the marble steps of the Supreme Court building, past the towering columns, past the words carved into the stone above the entrance, equal justice under law. Inside, the air is warmer, but no less solemn. The hallways are wide, lined with portraits of justices long dead. The marble floors echo with every footstep. You feel the weight of history here, not as abstraction, but as presence. Every decision made in this building becomes part of the architecture of American law. Every word spoken here is measured, recorded, preserved. You are here because the case has arrived. Not just Miranda versus Arizona, but 3 others with it. They have been consolidated, bound together by a single question. The Supreme Court has agreed to hear them all at once. Miranda versus Arizona, Vignera versus New York, Westover versus United States, California versus Stewart. 4 cases, 4 men, 4 confessions, 4 interrogation rooms where no lawyer was present, where no warning was given, where silence was never offered as an option. You sit in the gallery, watching as the lawyers take their positions. The courtroom is smaller than you imagined. The ceiling is ornate, the walls paneled in dark wood. The justices sit behind a long, curved bench, robed in black, their faces impassive. There are 9 of them. Chief Justice Earl Warren sits at the center. You have heard of him. Everyone has. He is the man who led the court in Brown versus Board of Education, the decision that ended legal segregation in schools. He is the man who believes the Constitution is not static but living, something that must adapt to the world it governs. The other justices sit beside him: Hugo Black, William O. Douglas, Tom Clark, John Marshall Harlan II, William Brennan, Potter Stewart, Byron White, Abe Fortas. Each one a mind, a philosophy, a lifetime of legal thought compressed into a single vote. The courtroom is full, but quiet. You hear the rustle of paper, the creak of wooden benches. The clerk calls the case. The justices listen. Some lean forward, some take notes. Chief Justice Warren's face is unreadable. Then the questions begin. Justice Harlan speaks first. His voice is clipped, precise. He is a traditionalist, a believer in restraint. He asks Flynn if he is proposing that police officers must provide a lawyer to every suspect during questioning. Flynn does not flinch. Yes, Your Honor, or at the very least, they must inform the suspect of the right to have one. Harlan leans back. You can see the skepticism in his posture. This is not the way the law has ever worked. This is not the way the police have ever operated. To require warnings, to require lawyers during interrogation, this would be a seismic shift, a rewriting of the rules. Justice White speaks next. He is newer to the court, but his voice carries certainty. He asks Flynn if this rule would not make it nearly impossible for police to obtain confessions. Flynn pauses. Then he says quietly, "If the only way to obtain a confession is to keep a person in ignorance of their rights, then perhaps that confession should not be obtained." You hear the silence that follows. It is not empty. It is full of tension, of thought, of the unspoken collision between two visions of justice. One vision, the police must be free to question, to press, to persuade. Confessions are essential. Crime must be solved. Guilty people must be caught. The other vision, the Constitution is not a suggestion. It is a boundary. And if the state crosses that boundary, even in the name of public safety, then the state has acted unlawfully. The justices do not reveal their thoughts, not yet. They simply listen, ask, listen again. When Flynn's time is up, he steps down. Now it is the state's turn. The lawyer defending the conviction is Gary Nelson, the Attorney General of Arizona. He is tall, composed, and his voice is firm. He does not deny the facts. He does not deny that Miranda was interrogated without a lawyer, without a warning. He simply argues that none of that matters. He tells the court that confessions have always been a vital tool in law enforcement. He tells them that police officers are trained to question suspects, to read their behavior, to draw out the truth. He tells them that requiring warnings would cripple investigations, that guilty people would simply invoke their rights and walk free. And then he says something that you feel land like a stone in the room. The Constitution does not require the police to be defense attorneys. You sit with that sentence. You turn it over in your mind. It sounds reasonable. It sounds practical. But beneath it is a question. If the police are not required to tell you your rights, then who is? Justice Brennan asks Nelson if he believes the Fifth Amendment applies during interrogation. Nelson hesitates. Then he says, "The Fifth Amendment applies when a person is compelled to testify, but questioning is not compulsion. Questioning is investigation." Brennan does not look convinced. He presses further. But if a person does not know they have the right to remain silent, how is that not compulsion? Nelson's answer is careful. He says that ignorance of the law is not the state's responsibility. He says that people are presumed to know their rights. He says that the burden cannot be placed on police officers to educate every suspect. You hear the logic. You also hear the gap in it, the space between presumption and reality. Because the truth is that most people do not know their rights. Most people, when faced with authority, speak. They comply. They confess. The arguments continue. The justices ask about precedent, about the scope of the Fifth Amendment, about the practical consequences of any ruling they might make. They ask about the other three cases, Vignera, Westover, Stewart, each one a variation on the same theme. In each case, a confession was obtained without warning. In each case, the conviction was upheld. In each case, the question is the same. Is this constitutional? The session ends. The justices rise and disappear behind the velvet curtain. The courtroom empties slowly. You remain for a moment, sitting in the quiet. You think about the room in Phoenix. You think about Ernesto Miranda, sitting across from two detectives, not knowing he could leave, not knowing he could stay silent, not knowing he could ask for a lawyer. You think about how many rooms like that exist, how many interrogations, how many confessions, How many people who spoke because they did not know they did not have to? And you think about the justices, now gathered in their private conference room, beginning to deliberate. The deliberations are not public. They are held behind closed doors, in a room lined with law books and silence. The justices sit around a long table. Each one speaks in turn, beginning with the Chief Justice and moving down by seniority. No one interrupts. No clerks are present. No record is kept beyond their own notes. You cannot be in that room. But you can imagine it. You can imagine Earl Warren speaking first, his voice measured and grave. You can imagine him saying that the Constitution must mean something real, something tangible, something more than words on parchment. You can imagine him arguing that the Fifth Amendment is not a technicality, it is a safeguard. And safeguards only work if people know they exist. You can imagine Justice Black agreeing, his voice firm. He is a textualist, a believer in the plain meaning of the Constitution. And the Fifth Amendment is plain. No person shall be compelled to be a witness against himself. Compulsion, he might say, is not just physical force. It is pressure. It is ignorance. It is the weight of authority in a closed room. You can imagine Justice Douglas nodding. He has spent his career defending individual rights. He has no patience for state power that overreaches, that assumes guilt, that treats suspects as obstacles rather than citizens. But you can also imagine Justice Harlan shaking his head. He respects precedent. He respects tradition. And the tradition, for as long as anyone can remember, has been that police are allowed to question suspects without issuing warnings. To change that now would be to overturn decades of practice. It would be judicial activism. It would be the court stepping into the role of policymaker. Justice White might agree with Harlan. He is pragmatic. He is skeptical of rules that tie the hands of law enforcement. He might argue that the court's job is not to make policing easier or harder. It is simply to interpret the Constitution. And the Constitution, as written, does not require warnings. You can imagine the debate stretching for hours. You can imagine the votes being counted, recounted. You can imagine Chief Justice Warren working to build a majority, to find common ground, to draft an opinion that will survive scrutiny and time. The conference ends. The justices return to their chambers. The opinion is assigned, and then, for months, there is silence. You are outside the court now, standing on the steps as winter turns to spring. The city begins to warm. The cherry blossoms bloom along the tidal basin. The case does not disappear. It lingers in the background of the legal world, whispered about in law schools, debated in journals, referenced in newspapers. People begin to take sides. Law enforcement groups issue statements. They warn that requiring warnings will handcuff the police, that crime will rise, that guilty people will go free. They argue that confessions are the lifeblood of investigations, and that this case threatens to drain that blood. Civil liberties groups respond. They argue that the Fifth Amendment is not optional. They argue that justice cannot be built on ignorance. They argue that if a confession is only valuable because the suspect did not know they could refuse, then it is not a confession, it is coercion. You read the editorials, you listen to the debates, you feel the tension building, the sense that this case is not just about Ernesto Miranda, but about something much larger, about the balance between order and liberty, about who the Constitution protects and when and how. And then, on a Monday morning in June, the decision is released. The arguments are made, the votes are cast, the justices retreat into silence, and the nation waits. You are back inside the Supreme Court. It is June 13th, 1966. The morning is bright, almost too bright, the kind of light that makes the marble gleam and the shadows sharp. The courtroom is packed. Lawyers, journalists, law students, observers, everyone has come to hear the decision. There is no announcement beforehand. There is no warning. The court simply convenes, and the Chief Justice begins to speak. Earl Warren's voice is steady, unhurried. He does not read from notes. He reads from the opinion itself, the document that has been drafted, revised, debated, and finalized over the past 4 months. His voice fills the room, and you feel the weight of each word as it is spoken aloud. The cases before us, he begins, raise questions which go to the roots of our concepts of American criminal jurisprudence. You sit still, you listen. He continues. We start here, as we did in Escobedo, with the premise that our holding is not an innovation in our jurisprudence, but is an application of principles long recognized and applied in other settings. The reference to Escobedo versus Illinois is deliberate. That case, decided 2 years earlier, had begun to crack open the door. It held that a suspect who asks for a lawyer during interrogation must be allowed to consult with one. But it was narrow. It left too many questions unanswered. Miranda is the court's attempt to answer them. Warren's voice does not waver. He speaks of the history of the Fifth Amendment, of its roots in the English common law, of the centuries-old principle that no person should be forced to accuse themselves. He speaks of the pressures inherent in custodial interrogation, the isolation, the authority, the psychological weight of 2 police officers standing over a suspect in a locked room. And then he says the thing that will echo for decades. Prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. You feel the room shift. Not visibly, not loudly, but the air changes. Because this is not just a legal principle. This is a rule, a mandate, a requirement. Warren continues, his tone firm but not harsh. He explains that these warnings are necessary to protect the privilege against self-incrimination. He explains that without them, the interrogation process is inherently coercive, that the imbalance of power between the state and the individual is too great to be ignored. He addresses the concerns raised by law enforcement. He acknowledges that confessions are valuable. He acknowledges that police work is difficult, but he says, and you hear the conviction in his voice, that the Constitution is not negotiable. It does not bend to convenience. It does not yield to necessity. If the individual indicates in any manner, at any time prior to or during questioning, that he wishes to remain silent, the interrogation must cease. You hear the simplicity of it, the clarity, the finality. He goes on. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. There is no ambiguity. There is no exception. The rule is absolute. Warren concludes the oral announcement. He does not linger. He does not invite questions. The opinion has been delivered. The decision is made. The vote is 5-4. In favor, Warren, Black, Douglas, Brennan, Fortas. Dissenting, Harlan, White, Stewart, Clark. It is close. It is fractured, but it is decided. You sit in the stillness that follows. You watch as the journalists scramble to leave, to file their stories, to get the news out. You watch as the lawyers exchange quiet words, some nodding, some shaking their heads. You watch as the public slowly filters out and the courtroom empties once more. And you think about what just happened. The Supreme Court of the United States has just created what will become known forever after as the Miranda warning. The dissents are sharp. Justice Harlan writes first. His tone is measured but firm. He does not dispute the importance of the Fifth Amendment. He disputes the court's authority to impose this solution. He argues that the Constitution does not require these warnings, that the court is legislating from the bench, that this decision will hamstring law enforcement and make it nearly impossible to obtain confessions. He writes, "The court's new rules will measurably weaken the ability of the criminal law to perform its tasks." Justice White's dissent is harsher. He is blunt, almost angry. He writes that the decision represents a misguided effort to protect the guilty at the expense of the innocent. He argues that confessions are essential to solving crimes and that the majority has prioritized the rights of criminals over the safety of the public. He writes, "In some unknown number of cases, the court's rule will return a killer, a rapist, or other criminal to the streets to repeat his crime whenever it pleases him." You read the words and feel their force. These are not abstract objections. They are warnings, predictions, fears. But the majority does not retreat. In the opinion, Warren addresses these concerns head-on. He argues that the Constitution is not a document of convenience. It is a document of principle. And if the price of upholding that principle is that some guilty people go free, then that is a price the Constitution requires us to pay. He writes, "The quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of its criminal law." You sit with that sentence. You turn it over. You feel its weight. Because this is the heart of the decision. Not whether Miranda is guilty, not whether confessions are useful, but what kind of country America wants to be, what kind of justice it wants to have. A justice that protects even those who do not know they need protection. A justice that demands the state speak the language of rights before it asks a single question. A justice that says, you do not have to speak. The reaction is immediate. Within hours, the decision is front-page news. Headlines scream across the country. Supreme Court limits police interrogations. New rules for confessions. Miranda decision, a win for defendants, a loss for police. Police chiefs hold press conferences. They express frustration, confusion, anger. Some say the decision will make their jobs impossible. Some say it will lead to a wave of unsolved crimes. Some say the court has gone too far. Civil rights organizations celebrate. The ACLU calls it a landmark victory. Defense attorneys say it will finally level the playing field. Law professors begin writing articles, dissecting the opinion, analyzing its implications. And across the country, in police stations and sheriff's offices and interrogation rooms, officers begin to adapt. They print cards, small, laminated cards that fit in a shirt pocket. On the cards, the words are typed out clearly. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. This is the Miranda warning. It will be read millions of times. It will become part of the fabric of American law enforcement. It will be recited in movies, in television shows, in novels. It will be so familiar that children will know it before they understand what it means. But in June of 1966, it is brand new. It is strange. It is untested. And for Ernesto Miranda, sitting in a prison cell in Arizona, it means something very specific. It means his conviction has been overturned. The Supreme Court did not declare Miranda innocent. It did not say he did not commit the crime. It said only that his confession was obtained in violation of the Fifth Amendment, and that without that confession, the case must be tried again. The state of Arizona decides to retry him. This time, the confession is not used. The prosecutors rely instead on other evidence. They call witnesses. They call the victim. She testifies. She identifies Miranda. She describes what happened that night in the desert. The jury deliberates. They convict him again. Miranda is sentenced, once more, to prison. You sit with the irony of it. The case that changed American law did not save the man at its center. He won his appeal. He lost his freedom. But the case is no longer about him. It has become something larger. It has become a principle, a rule, a piece of the constitutional architecture that will outlast every person involved in it. You are standing now in the years that follow. You watch as the Miranda decision is tested, challenged, refined. Lower courts issue rulings interpreting its scope. Some expand it, some narrow it. The Supreme Court hears follow-up cases, clarifying when the warnings must be given, when they can be waived, what happens if they are not followed. The warnings become routine. They become muscle memory. Officers recite them without thinking. Suspects hear them without always understanding. But they exist, and that existence, that simple, mandatory recitation, changes the balance of power in every interrogation room in America. You think about the room in Phoenix. You think about Ernesto Miranda sitting across from two detectives, not knowing he could say no. You think about how many people in how many rooms have sat in that same position. And you think about how many of them, because of this case, will now be told, you do not have to speak. It is not a perfect system. It is not a guarantee of justice. People still confess. People still waive their rights. People still sit in rooms with police officers and say things they will regret. But now at least they are told. Now at least the state must speak first. Now at least the Constitution reaches into that room and says, you have rights, and you have the right to know them. You are sitting in the quiet after the storm. The case is over. The decision is rendered. The rule is established. But the questions remain. Does this make us safer? Does this make us freer? Does this protect the innocent, or does it shelter the guilty? The answer, as with so many things in law, is, it depends. It depends on the police officer who reads the warning. It depends on the suspect who hears it. It depends on the lawyer who is called or not called. It depends on the judge who evaluates whether the waiver was voluntary. It depends on the culture of the police department, the resources of the public defender's office, the education of the suspect, the circumstances of the crime. The Miranda decision is not a magic spell. It is a rule, and rules only work when they are followed, enforced, respected. But it is also a promise that the state will not take your words without first giving you the chance to withhold them, a promise that the power to remain silent is not something you have to discover on your own, a promise that the Constitution is not just a shield you carry, it is a shield you are handed. You stand now at the edge of history. You look back at the room in Phoenix, at the courtroom in Washington, at the pages of the opinion that will be studied for generations, and you feel the stillness of it, the strange, slow way that law changes, not with a shout, but with a sentence, not with a revolution, but with a warning. You have the right to remain silent. 5 words, 24 letters, a sentence that will be spoken more than any other in American criminal law. And it began here, in a small room, with a young man who did not know he did not have to speak. The confession is broken, the rule is born, The silence, at last, is protected. You are in a courtroom in Phoenix, Arizona. It is 1967. A year has passed since the Supreme Court's decision. The air in the room is thick with anticipation, but also with something heavier: repetition. This is the second trial of Ernesto Miranda. The same crime, the same defendant, the same victim, but not the same evidence. The confession is gone. You sit in the gallery, watching as the prosecutor rises. His name is Robert Corbin. He is careful, methodical. He knows the case has already made history. He knows that every move he makes will be scrutinized. He does not have the signed statement anymore. He does not have the words Miranda spoke in that small, pale room. But he has other things. He has the victim. She takes the stand. Her name is withheld from the public record. She is referred to only as Jane Doe in the transcripts. She is 20 years old now. She sits with her hands folded in her lap, her voice quiet but steady. The prosecutor asks her to describe what happened on the night of March 2nd, 1963. She does. You listen as she recounts the abduction, the bus stop, the car pulling up, the man who told her to get in, the drive into the desert, the assault, the way she was left on the side of the road, alone, in the dark. Her voice does not break, but you can hear the weight in it, the years between that night and this moment, the way memory holds trauma in suspension, neither fading nor sharpening, just persisting. The prosecutor asks her if she sees the man who assaulted her in the courtroom. She looks up. She looks at Ernesto Miranda. She nods. "That's him," she says. You watch the jury. Some of them are looking at her. Some are looking at Miranda. Some are looking down at their hands, their faces unreadable. The defense attorney, Alvin Moore again, the same court-appointed lawyer who represented Miranda the first time, rises for cross-examination. He is gentle but persistent. He asks about the identification. He asks about the lineup she viewed at the police station, about whether she was certain then, about whether she is certain now. She says she is certain. Moore does not press too hard. He knows the danger of appearing to attack a victim. He knows the jury is watching not just her, but him. He asks a few more questions, then sits down. The prosecutor calls other witnesses. He calls the detectives who investigated the case. He calls forensic experts. He builds a circumstantial case, not airtight, but solid enough. He shows that Miranda owned a car matching the description. He shows that he was in the area that night. He shows that he had a criminal history. But he does not mention the confession. He cannot. The Supreme Court has taken it away. You watch as the defense presents its case. Moore calls character witnesses. He calls alibi witnesses, though their testimony is vague, uncertain. He argues that the identification is unreliable, that the case is built on assumptions, that reasonable doubt exists. The trial lasts several days. The jury deliberates for 9 hours. They return with a verdict: guilty. You watch Miranda's face. It is the same as before, expressionless, resigned. He does not react. He simply sits, waiting for the sentence. The judge sentences him to 20 to 30 years in prison, the same sentence as before. You sit in the stillness after the gavel falls. You think about what this means. The Miranda decision was supposed to protect him. It did. It overturned his first conviction. But it did not set him free. It did not erase what happened. It simply reset the process, and the process led back to the same place. The case, you realize, was never really about Ernesto Miranda. It was about everyone who would come after him. Once are in a police station now, somewhere in America. It could be anywhere: Detroit, Los Angeles, Atlanta, Boise. The location does not matter. What matters is the room. It is small, windowless. A table, 2 chairs, a camera in the corner, its red light blinking. A suspect sits in one chair. An officer sits in the other. The officer holds a laminated card. He reads from it, his voice practiced, automatic. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights as I have read them to you? The suspect nods. I need you to say it out loud, the officer says. Yes, the suspect says, I understand. Do you wish to waive these rights and speak with me? The suspect hesitates. You see it, the flicker of uncertainty, the moment of decision, and then, yeah, I guess. The officer clicks his pen. He begins to write. The interrogation continues. You watch this scene play out in 1,000 variations, in 1,000 rooms, across years and decades. Sometimes the suspect asks for a lawyer. Sometimes the interrogation stops. Sometimes it does not. Sometimes the officer presses forward, and later a judge will have to decide whether the waiver was truly voluntary, whether the suspect understood, whether the system worked the way it was supposed to. The Miranda warning is not magic, it is words, and words can be spoken without being heard, understood without being believed, agreed to without being meant. But they are spoken. That is the change. That is the shift. The state must now, always, say them first. You are in a law school classroom years later. The professor is teaching criminal procedure. She writes on the board, Miranda v. Arizona, 1966. She turns to the class. This case, she says, is one of the most famous in American legal history. Can anyone tell me why? Hands go up. Students offer answers. It created the Miranda warning. It protects the Fifth Amendment during interrogation. It changed how police question suspects. The professor nods. All true, but let me ask you this. Did it work? The room goes quiet. She continues. Studies show that after Miranda, the confession rate dropped, but only slightly. Most suspects still waive their rights. Most still talk to the police. So what did Miranda actually accomplish? A student raises her hand. It made the system more fair. Even if people still confess, at least they know they don't have to. Another student counters. But if they don't really understand their rights, what's the point? It's just a ritual, a formality. The professor does not answer. She lets the debate unfold. Because there is no single answer. The question is still open, decades later. Did Miranda protect the vulnerable, or did it just create the illusion of protection? Did it restrain police power, or did it simply teach officers how to extract waivers more effectively? Did it change the culture of interrogation, or did it just change the script? You sit in the back of the classroom, invisible, listening. You think about the room in Phoenix. You think about the thousands of rooms since then. You think about the words spoken, the rights waived, the confessions given, and you think, maybe the point is not whether it solved the problem. Maybe the point is that it tried. You are in the Supreme Court again. It is 1984. Nearly 20 years have passed since Miranda. The case before the court is New York v. Quarles. The facts are simple. A woman tells police that a man with a gun raped her. She describes him. Police find him in a grocery store. They frisk him. They find an empty shoulder holster. One officer asks, "Where's the gun?" The man points to a stack of boxes. The gun is over there. The officer retrieves the gun. Only then does he read the Miranda warning. At trial, the defendant's lawyer argues that the statement, "The gun is over there," should be suppressed. It was obtained before the warning was given. It violates Miranda. The trial court agrees. The statement is excluded. The case reaches the Supreme Court, and the court, now more conservative than it was in 1966, creates an exception. It is called the public safety exception. The court rules that when there is an immediate threat to public safety, officers may ask questions before giving the Miranda warning. The gun, they say, posed a danger. The question was necessary. The statement can be used. You sit with this new rule. You feel the ground shift slightly beneath Miranda. Not a collapse, not a reversal, but an erosion, a small carving out. And it is not the only one. Over the years, the court creates other exceptions, other qualifications. The warnings must be given, but there are circumstances where silence can be used against you. The warnings must be clear, but they do not have to be perfect. The right to a lawyer must be honored, but only if it is invoked unambiguously. Each case narrows Miranda just a little. Each case adds a footnote, a caveat, a but. The principle remains, the rule remains, but its edges are softer now, more porous. You think about Earl Warren's words. The quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of its criminal law. And you wonder, what happens when those methods keep changing? What happens when the rule bends, little by little, case by case? You are standing outside a prison in Arizona. The year is 1976. A decade has passed since Miranda versus Arizona was decided. Ernesto Miranda has been paroled. He is no longer a young man. He is 34 now, weathered, marked by years behind bars. He finds work. He struggles. He drifts. He sells autographed Miranda warning cards on the street for $1 or $2 each. A strange footnote to his place in history. One night in January, he is in a bar in Phoenix. There is an argument, a fight. Knives are drawn. Ernesto Miranda is stabbed. He bleeds out on the floor. The police arrive. They find witnesses. They make an arrest. The suspect is read his rights, the rights that bear Miranda's name. You have the right to remain silent. The suspect invokes those rights. He does not speak. He is released. The case goes unsolved. You stand at the edge of this irony, this strange circular ending. The man whose name became synonymous with the right to silence died in a way that let his killer remain silent. History is not neat. It does not tie itself into lessons. It simply unfolds, ambiguous and human. You are in a different courtroom now. The place does not matter. The time does not matter. What matters is the pattern. A defendant is on trial. The prosecution wants to use his confession. The defense challenges it. Did the officer give the Miranda warning? Yes. Did the defendant waive his rights? He said yes, but did he understand? Was he coherent? Was he under the influence? Was he intimidated? Was the waiver truly voluntary? The judge listens. The judge rules. Sometimes the confession is admitted. Sometimes it is suppressed. It depends on 100 small factors, 100 tiny details. This is how Miranda lives in the real world, not as a clear line, but as a battlefield, a place where prosecutors and defense attorneys fight, where judges weigh credibility, where juries try to decide what really happened in a room they were not in. The warning is given, but the question is never fully settled. Was it enough? You sit in the gallery, watching this case, and the next one, and the one after that. You see the same arguments repeated. You see the same frustrations. You see defense attorneys fighting to suppress confessions and prosecutors fighting to admit them. and judges trying to navigate the murky waters between coercion and consent. And you see defendants, some guilty, some innocent, some somewhere in between, caught in the machinery of it all. The system is not perfect, but it is trying. That is what Miranda gave us, the requirement to try. You are sitting now in the quiet between arguments. You are thinking about what justice means. Does it mean that guilty people are convicted? Does it mean that innocent people go free? Does it mean that the process is fair, even when the outcome is painful? There is no single answer. There never has been. But Miranda gave us a tool. An imperfect tool, yes. A tool that can be misused, evaded, eroded, but a tool nonetheless. It said, "Before the state takes your words, it must first give you a choice." It said, "The Constitution is not something you have to discover on your own. It is something you are owed." It said, "Silence is not weakness. It is a right." And for all the exceptions, all the erosions, all the ways the rule has been tested and bent and challenged in the decades since, that core idea remains. You have the right to remain silent. Not because you are guilty, not because you have something to hide, but because you are a person, and the state must treat you as one. The trial repeats. The warnings are spoken. The law bends but does not break. And the words, once given, cannot be taken back. You are in a conference room inside the Department of Justice. It is a bright autumn day in 1999. The windows overlook Pennsylvania Avenue, and if you listen closely, you can hear the faint hum of the city beyond, traffic, voices, the movement of a capital that never quite rests. A group of lawyers sits around a polished table. They are reviewing a brief. The case is Dickerson versus United States, and it is winding its way toward the Supreme Court. The question before them is deceptively simple, but its implications are vast. Can Congress overrule Miranda? You lean forward. You feel the tension in the room. Because this is not an academic debate. This is a direct challenge to one of the most famous rulings in American constitutional history. The story begins in 1968, 2 years after Miranda was decided. Congress, frustrated by the decision, passed a law. It was buried inside the Omnibus Crime Control and Safe Streets Act, a sweeping piece of legislation aimed at cracking down on crime. Section 3501 said, in essence, that confessions should be admissible in federal court as long as they were given voluntarily, regardless of whether Miranda warnings had been provided. The law was a direct rebuke to the Supreme Court. It said, "The warnings are not required. They are not constitutionally mandated. They are merely a judicial suggestion, and Congress has the power to replace them with a different rule." For 30 years, the law sat dormant. Federal prosecutors did not use it. They continued to give Miranda warnings. They did not test the statute. They left it alone, a piece of legislative defiance that never saw the light of day. Until now. A man named Charles Dickerson was arrested by the FBI in connection with a bank robbery. He confessed. But there was a problem. The agents had delayed giving him the Miranda warning. His lawyer moved to suppress the confession, arguing that Miranda required exclusion. The prosecutors, for the first time in decades, invoked Section 3501. They argued that even without the warnings, the confession was voluntary. They argued that the statute permitted its use. The district court suppressed the confession anyway. The government appealed. The Fourth Circuit Court of Appeals reversed, ruling that Section 3501 was valid and that Miranda was not a constitutional rule. It was merely a procedural guideline that Congress could modify. And now the case is headed to the Supreme Court. You sit in the stillness of the conference room. You watch the lawyers debate strategy. Some think the law is unconstitutional, that the court will strike it down and reaffirm Miranda. Others are less certain. The court has changed since 1966. It is more conservative now. Chief Justice Rehnquist, who wrote a harsh dissent in a later Miranda case, is now leading the court. He has never been a fan of the decision. What will the court do? You are in the Supreme Court building again. The date is April 19th, 2000. The marble halls are the same as they were 34 years ago, but the faces are different. The justices are different. The world outside is different. The courtroom fills. The lawyers take their positions. The case is called. The lawyer defending Section 3501 stands and argues that Congress has the constitutional authority to regulate the admissibility of evidence in federal court. He argues that Miranda was not a constitutional decision. It was a prophylactic rule, a safeguard created by the court to protect the Fifth Amendment, but not mandated by the Fifth Amendment itself. Therefore, Congress can replace it with a different safeguard. It is a clever argument. It takes Miranda's own language and uses it as a weapon. The court itself had said the warnings were not the only way to protect the privilege against self-incrimination, just one way. If there are other ways, the argument goes, then Congress can choose a different one. The justices ask questions. They probe. They push. Justice Scalia, a textualist and an originalist, seems sympathetic to the argument. He has long been skeptical of Miranda, viewing it as judicial overreach. Justice Thomas, similarly, has written critically of the decision. But Justice Kennedy asks a different question. He asks what would happen if the court upheld Section 3501. Would it mean that Miranda was not really the law? Would it mean that every confession obtained without warnings, not just in federal court but in state court, would have to be reevaluated? The lawyer hesitates. The implications are staggering. If Miranda is not a constitutional rule, then states are not bound by it. Every state could adopt its own standard. The law would fracture. The protections would vary. The clarity that Miranda provided, the single, uniform rule that applies everywhere, would be lost. The oral argument ends. The justices retreat. The wait begins. You are sitting in a law library, months later, when the decision is released. It is June 26th, 2000. The opinion is written by Chief Justice Rehnquist, the same justice who has spent decades criticizing Miranda. You open the document, you begin to read, and you are stunned. Rehnquist upholds Miranda. He writes that Miranda is a constitutional decision. He writes that Congress cannot overrule it. He writes that the warnings are not merely a suggestion, they are a constitutional requirement derived from the Fifth Amendment and therefore beyond the reach of legislative modification. He writes, Miranda has become embedded in routine police practice to the point where the warnings have become part of our national culture. You sit with that phrase, embedded, national culture. This is not just a legal argument. This is an acknowledgement of reality. Miranda has lasted. It has survived challenges, exceptions, erosions. It has been tested for 34 years and it has not broken. Police officers know it, suspects know it, the public knows it. It is part of the fabric now. And because it has become embedded, the court says, it cannot be uprooted. The vote is 7-2. Even justices who might have ruled differently in 1966 now vote to preserve the rule. Because overturning Miranda would cause chaos. It would unsettle decades of precedent. It would shatter the expectations of law enforcement, defendants, courts. The dissenters, Scalia and Thomas, are furious. They argue that the majority is rewriting history, that Miranda was always a flawed decision, that the court is clinging to it out of stubbornness rather than principle. But the majority does not budge. Miranda survives. You are in a police academy now, somewhere in America. The year does not matter. The place does not matter. What matters is the training. A young recruit sits in a classroom, listening to an instructor. The instructor holds up a laminated card. "This," he says, "is your Miranda card. You will carry it with you at all times. You will read it before every custodial interrogation. You will read it word for word. You will not paraphrase. You will not skip lines. You will not assume the suspect already knows their rights. You will read it every time." The recruit nods. He takes notes. He knows this is not optional. He knows that if he forgets, if he skips it, if he makes a mistake, the confession will be thrown out. The case will be lost. His work will be undone. The instructor continues. After you read the warnings, you will ask if they understand. You will ask if they are willing to waive their rights and speak with you. If they say no, you stop, immediately. No more questions. If they ask for a lawyer, you stop, immediately. No exceptions. The recruit nods again. He understands. This is the rule. This is how it works now. The instructor pauses. Then he says something the recruit will remember for the rest of his career. Some of you will hate this rule. Some of you will think it lets guilty people go free. Maybe it does, but this is the deal we made. This is the price of living in a country where the government has to respect your rights, even when it's inconvenient, even when it's frustrating, even when we know someone is guilty. The room is quiet. You sit in the back, invisible, listening, and you think, this is what Miranda has become. Not just a legal rule, but a philosophy. A reminder that the Constitution is not a tool for catching criminals. It is a boundary around power. You are standing in an interrogation room now. The suspect is a young man, barely 20. He is nervous, fidgeting, his eyes darting between the officer and the door. The officer reads the warnings from his card. "Do you understand these rights?" The young man nods. "I need you to say it." "Yeah, I understand." "Do you want to talk to me?" The young man hesitates. You see it, the moment of doubt. He has been told he has the right to remain silent. He has been told he has the right to a lawyer. But he is also afraid. Afraid of what will happen if he says no. Afraid of looking guilty. Afraid of making things worse. "Yeah," he says finally, "I'll talk." The officer nods. He clicks his pen. The interrogation begins. And you think, this is the gap. This is the space where Miranda cannot reach. Because the warnings are given, the rights are explained, but understanding is not the same as comprehension. Consent is not the same as freedom. The young man talks. He says things he should not say. He implicates himself. Later, in court, his lawyer will argue that the waiver was not truly voluntary. The judge will disagree. The confession will be admitted. Miranda protected him, but it did not save him. You are sitting now in the space between ideals and outcomes. You are thinking about what Miranda promised and what it delivered. It promised that the Constitution would reach into the interrogation room. It delivered warnings, words spoken, rights explained. It promised that suspects would have a choice. It delivered that choice, but not the wisdom to make it, not the courage to invoke it, not the resources to enforce it. It promised fairness. It delivered process, and process is not always the same as justice. But maybe that is all the law can do. Maybe the law is not a shield that stops every blow. Maybe it is just a marker, a line drawn in the sand, a statement of principle, a reminder that power must be checked, even if imperfectly. You think about Ernesto Miranda sitting in that small room in Phoenix, confessing without knowing he didn't have to. You think about the thousands of people who have sat in rooms like that since then. Some were told their rights, some understood, some invoked them, some did not. The warnings are given, but the silence is still hard to find. You are in a library now, reading case after case. You see the pattern. Miranda is cited hundreds of times every year. It is challenged, tested, refined. Courts argue over what counts as custody, what counts as interrogation, what counts as a valid waiver, what counts as an invocation of rights. The rule is clear, but its application is endlessly complex. A suspect says, "Maybe I should talk to a lawyer." Is that an invocation? Some courts say yes, some say no. A suspect says, "I don't want to talk about this." Is that an invocation of the right to silence? Some courts say yes. Some say it depends on what this means. A suspect waives his rights, then changes his mind halfway through the interrogation. Can the first half of the confession be used? Some courts say yes. Some say no. The law is not simple. It is a web of precedents, exceptions, qualifications, and in that web, people get caught. But the warnings are still given. The requirement still stands. Miranda is still the law. You are standing at the threshold of summation now. The evidence has been presented. The testimonies have been heard. The arguments have been made. And now it is time to gather the threads, to weave them into something the jury can hold. You feel the weight of what comes next, because this is where the story turns. This is where words become verdicts. This is where silence, at last, is given its final meaning. The rule endures. The warnings are spoken. The silence is protected, but not always found. And the question remains, is this enough? You are in a small, windowless room. Not an interrogation room this time, a jury room. The trial is over. The evidence has been presented. The witnesses have testified. The lawyers have made their closing arguments. Now 12 people sit around a table, and they must decide. The case does not matter. The crime does not matter. What matters is the moment, the pause before judgment, the silence before the verdict. You sit among them, invisible, watching their faces. Some are confident, some are uncertain. One juror drums his fingers on the table. Another stares at the ceiling. A woman near the window looks at her hands. The foreperson clears her throat. "So," she says, "let's talk about the confession." This is always where it begins, because in the decades since Miranda, confessions have remained the most powerful evidence in criminal trials. Jurors trust them, they believe them, even when they know the warnings were given, even when they know the defendant had the right to remain silent. The fact that he spoke carries weight. One juror says, "He knew his rights, the officer read them. He said he understood. He said he'd talk. That's on him." Another juror, quieter, says, "But did he really understand? He was 19. He'd never been arrested before. He was scared." "Scared doesn't mean the confession is invalid," the first juror replies. "Scared is not the same as coerced." You listen. You hear the debate that has played out in jury rooms across the country, in courtrooms across decades. The warnings were given, but were they enough? The jurors argue, they deliberate. Eventually, they vote. Guilty. The confession stands. You sit in the aftermath, in the silence after the verdict is read, and you think, Miranda gave the warnings, but it could not control what happened after they were spoken. You are in the Supreme Court one more time. The year is 2010. The case is Berghaus versus Tompkins. The facts are familiar. A man was interrogated for nearly 3 hours. He was given the Miranda warnings. He did not say he understood them. He did not say he waived them. He simply sat, mostly silent, answering only a few questions with brief, monosyllabic responses. Near the end of the interrogation, the officer asked, "Do you pray to God to forgive you for shooting that boy down?" The man said, "Yes." That was the confession. One word. After 3 hours of near silence. At trial, the defense moved to suppress it, arguing that the man had never waived his Miranda rights. He had never said he was willing to talk. He had simply endured the interrogation in silence. The trial court admitted the confession. The conviction was upheld on appeal. And now the Supreme Court must decide, does silence equal waiver? The court rules 5-4. The majority says, if a suspect understands his rights and does not invoke them, his silence can be treated as an implicit waiver. If he answers questions, even sporadically, that is evidence of waiver. The burden is on the suspect to affirmatively invoke his rights. Silence alone is not enough. The dissent is sharp. Justice Sotomayor writes that the decision turns Miranda upside down. She argues that the whole point of Miranda was to protect people who do not know how to protect themselves, who do not know that silence is an option. To require them to affirmatively invoke their rights is to place the burden on the most vulnerable, the least informed, the most easily overwhelmed. She writes, "Today's decision turns Miranda into a trap for the unwary." You sit with those words, you feel their weight, because this is the arc of Miranda, a rule created to protect, slowly reshaped by exception and qualification, until the protection becomes conditional, until the shield has gaps. The warnings are still given, but the silence must now be spoken. You are standing in an interrogation room one last time. The walls are the same pale color. The light is the same fluorescent hum. The table is metal. The chairs are hard. An officer sits across from a suspect. The officer reads from his card. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights? The suspect nods. Do you wish to speak with me? The suspect looks at the table, looks at the officer, looks at the door, and then, quietly, "I want a lawyer." The officer closes his notebook. He stands. He leaves the room. The interrogation is over. You sit in the silence that follows. You feel the power of those 4 words, "I want a lawyer," and the way they can stop everything. The way they can change the course of a case, the way they can protect a person, even from themselves. This is what Miranda made possible. Not a guarantee, not a shield that never fails, but a possibility, a chance, a door that can be closed if you know it is there. You are sitting now in the long view of history. Miranda v. Arizona was decided in 1966. Nearly 60 years have passed. The warnings have been given billions of times. The case has been cited, challenged, narrowed, defended, reaffirmed. It has not solved the problem of coerced confessions. It has not eliminated wrongful convictions. It has not made the system perfect, but it has made the system speak. Before Miranda, the interrogation room was a black box. What happened inside was invisible, unrecorded, unreviewable. Suspects spoke without knowing they didn't have to. Confessions were extracted through ignorance as much as through pressure. After Miranda, the state must announce its limits. It must tell you, before it asks, that you have a choice. Is that enough? No, not always, not for everyone. But it is something. It is a line. It is a rule. It is a requirement that the government, before it takes your words, must first give you the chance to withhold them. And in a system built on power, where the state has resources, authority, the machinery of law behind it, and the suspect often has nothing, that requirement matters. It matters because it is a recognition, an acknowledgement, a statement that the person sitting in that room is not just a subject to be interrogated, but a citizen with rights. It matters because it says the Constitution does not stop at the courthouse door. It goes with you, into the interrogation room, into the moment of accusation, into the silence before you speak. You are standing now at the end of the story, but the story does not end. Every day in police stations across the country, the warnings are read. Every day, suspects hear them, understand them, or do not, waive them or invoke them. Every day, confessions are given, cases are built, trials are held, verdicts are rendered. Every day, Miranda lives, not as a monument, not as a perfect solution, but as a practice, a ritual, a reminder. You have the right to remain silent. 5 words, spoken so often they risk becoming meaningless, but underneath them, a principle. You are not powerless. You are not without recourse. You are not required to participate in your own conviction. The state must tell you this, not because it wants to, but because the Constitution demands it. You are sitting in the stillness now. The courtroom is empty. The jury has gone home. The verdict has been read. The defendant has been led away. But the words remain. You think about the young woman who testified against Ernesto Miranda, her voice steady but weighted with memory. You think about the detectives in the small room, confident in their methods, unaware that they were making history. You think about the justices in 1966, divided and deliberating, trying to balance safety and liberty. You think about the officers today, reading from laminated cards, doing their jobs, following the rules. And you think about the silence that Miranda tried to protect, the silence that is still so hard to claim. Because the right to remain silent is not the same as the ability to do so. The warning is not the same as the understanding. The rule is not the same as the reality. But the rule matters, because without it, there is nothing. Without it, the interrogation room returns to what it was, a place where power speaks and the powerless answer. With it, there is at least a chance, a moment, a choice. You do not have to speak, and if you choose silence, the state must respect it. You rise from your seat. You walk out of the courtroom, down the marble hallways, past the portraits of justices, past the words carved in stone. Equal justice under law. It is an ideal, not a fact, not a guarantee, but an aspiration. Miranda is part of that aspiration, a piece of the architecture, a rule that says, even in the pursuit of truth, even in the fight against crime, even when the stakes are high and the pressure is real, the Constitution sets limits. And those limits are not suggestions, they are commands. The system is not perfect. The warnings are not magic. The protections are not absolute. But they exist. And that existence, however imperfect, is the difference between a state that must respect your rights, and one that does not have to acknowledge them at all. You stand on the steps of the courthouse now, in the open air. The sun is setting, the light is golden, slanting across the columns, warming the stone. The city moves around you, cars passing, people walking, the hum of a world that continues, indifferent to the weight of what happens inside these buildings. But you are not indifferent. You have walked through the story from beginning to end, from the small room in Phoenix to the marble halls of the Supreme Court, from one man's confession to a rule that governs a nation. And you understand now that Miranda is not just a case, it is a conversation that began in 1966 and has never stopped. A conversation about power and restraint, about guilt and innocence, about what we owe to each other when the state accuses and the individual must answer. Every time the warnings are read, the conversation continues. Every time a suspect invokes their rights, the conversation continues. Every time a court rules on whether a waiver was voluntary, whether an invocation was clear, whether the warnings were adequate, the conversation continues. It is not always a comfortable conversation. It is not always a satisfying one, but it is necessary. Because the alternative is silence of a different kind, not the silence of rights protected, but the silence of rights unspoken. The silence of a system that does not have to explain itself, that does not have to justify its power, that does not have to recognize the humanity of the person sitting in the interrogation room. Miranda broke that silence, and in doing so, it changed what it means to be questioned by the state in America. You think now about the other cases, the ones that never made it to the Supreme Court, the ones that never became famous, the ones where the warnings were given and the suspect understood and invoked their rights and walked out of the interrogation room without saying a word. Those cases do not make headlines. They do not appear in law school textbooks. They do not generate dissents or concurrences or decades of scholarly debate. But they are the success stories. They are the moments when Miranda worked exactly as it was supposed to, when the shield held, when the person knew their rights and exercised them, and the state respected that choice. Those cases are invisible, but they are everywhere. They happen every day. And they happen because of a decision made in 1966, because of a young man who confessed in a room in Phoenix, because of lawyers who saw in that confession a question that needed answering, because of justices who chose principle over convenience. You think about Earl Warren, the Chief Justice who wrote the majority opinion. He is long dead now, but his words remain, embedded in the law, recited in courtrooms, debated in classrooms. You think about Ernesto Miranda, who lived and died in obscurity, whose name became famous in a way he never was. He was not a hero. He was not a villain. He was a human being, flawed and complicated, whose moment of confession became a moment of constitutional reckoning. You think about the victim in the case, whose voice was heard in court, but whose name was kept from history. She testified twice. She identified her attacker twice. She lived with the memory of what happened to her, even as the case became about something larger than her pain. The law does not always serve everyone equally. The rules meant to protect can sometimes obscure. The focus on procedure can sometimes overshadow the people at the center of the story. But the rules still matter, because without them, there is only discretion, and discretion, unchecked, becomes power, and power, unchecked, becomes tyranny. Miranda is a check, an imperfect one, but a check nonetheless. You are walking now, away from the courthouse into the evening. The streetlights are beginning to flicker on. The air is cooling. The city is settling into night. You think about all the interrogation rooms that exist in this moment across the country. Some are empty, some are occupied. In some, the warnings are being read. In some, suspects are waiving their rights. In some, suspects are invoking them. In some, confessions are being given. In some, silence is being maintained. The system churns on. Cases are built. Trials are held. Verdicts are reached. Appeals are filed. Some convictions are upheld. Some are overturned. The machinery of justice moves, grinding and imperfect, but moving. And at every stage, Miranda is there. A baseline, a requirement, a reminder that even the accused have rights, and those rights must be honored. It is not a perfect system. It never will be. Because humans are imperfect, and the institutions they create are imperfect, and the application of rules is imperfect. But the attempt matters. The effort matters. The rule matters. Because the rule is a promise. And even when promises are broken, even when they are bent or eroded or forgotten, the fact that they were made changes something. It changes the expectation. It changes what we demand from power. It changes what we believe we are owed. You stand at a crossroads now, literal and metaphorical. You can go left, toward the monuments and memorials, the marble tributes to ideals and heroes. You can go right, toward the neighborhoods and streets, the ordinary places where ordinary people live and work, and sometimes confront the machinery of the state. You choose right, because this is where Miranda lives, not in monuments, but in practice, not in marble, but in laminated cards carried in pockets, not in grand declarations, but in quiet moments when someone says, "I want a lawyer," and the interrogation stops. You walk past row houses and corner stores, past bus stops and streetlights. You think about all the people who will never sit in an interrogation room, who will never need to invoke their Miranda rights, who will live their entire lives without ever testing whether the system protects them. And you think about the people who will, who already have, who are sitting in those rooms right now, facing questions, facing pressure, facing the choice between speaking and remaining silent. For them, Miranda is not abstract. It is real. It is the difference between knowing and not knowing, between having a chance and having none. You are sitting on a bench now in a small park. The night has deepened. The stars are faint above the city lights. The world is quiet, the kind of quiet that feels less like peace and more like pause. You think about the arc of this story. It began with ignorance, a man who did not know he did not have to speak. It moved through litigation, argument, deliberation, decision. It became a rule. The rule was tested, challenged, refined, eroded in some ways, strengthened in others. It endured. And now, decades later, it is simply part of the landscape, part of what it means to be arrested in America, part of the ritual of interrogation, part of the language of law enforcement. You have the right to remain silent. The words are so familiar now that we forget how revolutionary they once were. We forget that there was a time when the state did not have to say them. We forget that someone had to fight for them, that judges had to choose them, that the Constitution had to be read in a new way to require them. We forget, but the law remembers. The law carries the memory forward. In every case, in every citation, in every warning read from a card in an interrogation room, the memory persists. This is what law does. It takes moments of human conflict and transforms them into principles. It takes individual stories and makes them collective. It takes suffering and tries, imperfectly, inadequately, but persistently, to prevent it from recurring. Miranda is that transformation. It is the story of one man's confession becoming everyone's protection. Once stand now, ready to leave the park, ready to step back into the world where the story continues to unfold, where the warnings continue to be read, where the questions continue to be asked and sometimes answered, sometimes met with silence. You carry with you the knowledge of what this case means, not just the legal doctrine, not just the procedural requirements, but the deeper principle beneath it all, that dignity matters, that even the accused deserve respect, that the Constitution is not just for the powerful, but for everyone, that silence is not guilt, but a right, that the state must announce its limits before it can cross your threshold. These are not easy principles to uphold. They make law enforcement harder. They make convictions more difficult to obtain. They create space for guilty people to avoid consequences. But they also create space for innocent people to protect themselves, for vulnerable people to have advocates, for everyone to have a moment, however brief, to decide whether they will participate in their own accusation. And in a society built on the idea that the government must earn its authority, that power must be justified, that liberty is the default and restriction the exception, that space matters. You take one last look at the courthouse in the distance, its columns pale against the dark sky. Inside, the work continues. Cases are filed, arguments are made, judges deliberate, juries decide. The system, for all its flaws, persists. And somewhere, in a small room with fluorescent lights and metal furniture, an officer is reading from a card. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. The words float in the air between the officer and the suspect. They hang there, waiting, and the suspect must choose. That choice, that moment of decision, is what Miranda made possible. Not perfect protection, not a guarantee of justice, but a chance, a moment, a right spoken aloud that cannot be taken back. You walk into the night now, leaving the story behind but carrying its meaning with you. Miranda v. Arizona was decided on June 13, 1966, but it is decided again every day, in every interrogation room, in every courtroom, in every moment when someone must choose between speaking and remaining silent. The case is never truly over. The question is never fully settled. The conversation continues, and in that continuing conversation, in that ongoing struggle between power and liberty, between truth and rights, between what is convenient and what is constitutional, we find not answers, but commitments. A commitment to inform, a commitment to respect, a commitment to recognize that even in the pursuit of justice, even in the confrontation with crime, the individual still matters. The person sitting in that small room is not just a suspect, not just a case number, not just an obstacle to conviction or an opportunity for confession. They are a person, with rights, with dignity, with the constitutional protection of silence. And before the state can take their words, it must first give them the choice to withhold them. That is Miranda. That is its legacy. That is what it means, and will always mean, when an officer reads from a card and says, "You have the right to remain silent." The silence that follows those words, whether filled with speech or maintained in quietness, belongs to the person who hears them, and no one can take it away without their consent. The story ends. The rule endures. The words are spoken, and in the space between warning and response, freedom, however fragile, finds a place to breathe. The verdict we carry is not just guilty or innocent. It is the verdict that rights matter, even when they are inconvenient, especially then. The courtroom empties, the night deepens, but the promise remains. You have the right to remain silent, and that right, once spoken, becomes part of the law we all live under.